Here we're doing something even more interesting that goes back to control of lifestyle. Again, how can we have efficiency in the workplace and at the same time the right of privacy? And therefore, this part is really interesting because our employers permitted to monitor employees' behavior even off the work site. And I want you to know that the answer really is pretty much more and more, especially after 9/11, yes. And why is it? Because of the safety. Just like sometime we, under the umbrella of freedom of speech, we feel that we have a right to say anything we want to. More and more now, under the umbrella of safety, the government has police power, and they feel that they have a right to do a lot of things to protect us from getting hurt again. And nobody wants to get hurt. Nobody wants a 9/11 again. So we let the government do a lot of things that, under the umbrella of safety, is unconstitutional. And here is another situation where the employer, and if you think about it, the employer, especially if it's a public employment, the employer is the government. So are they, and of course for the good of society, we know pilots and we know the Department of Transportation can do that, can test you for drugs even off-site. We know pilots are tested because who wants to fly in a plane that the pilot is taking drugs or alcohol? So for the safety of the society at large, or for the reasonable people, the 55% or the 61%, whatever it is, as long as it's above 50%, they rather have the employer monitor the employee's behavior, even if it is off-site. Well, this is a very interesting case because it's something to do with smoking in 1995, the Kurtz case. Now, the slippery slope of privacy rights. By now, you probably will have no problem understanding that there is no privacy or right to privacy if we don't expect any privacy. So if the reasonable people do not expect any privacy, therefore there is no privacy. Employers have an interest not only in maintaining a safe workplace, but also in cutting health insurance costs. Here's a new one now. They are the ones that are paying for our employment benefit. They are the ones, so be very careful, because I know a situation where I had a vice president of a company calling me that 6 months ago they hired somebody, and now that is 6 months working for their company, and he also is a vice president. He has cancer of the liver, and he wanted to know if there's a way that as an employer they can test the applicant so that they don't hire another vice president that has a disease that after 6 or 7 or even 1 year, he's more cost to the company than producing anything. And of course, one way to do it is through drug testing. When they have that urine or they have that blood from you, I mean, there's a lot of things that they can find out today because of technology. Does this mean that the employers can refuse to hire individuals who are more likely than others to become ill because of off-duty habits, such as smoking? And here comes where the Supreme Court of Florida addressed this question in the following cases. There is not such a thing as the right to smoke. This is when a couple of years ago, when the Food and Drug Administration was considering to make nicotine a drug, I really was very concerned, because as a lawyer, if the Food and Drug Administration, the FDA, is approved to define nicotine as a drug, that means a smoker then is disabled. And here's a case that I found very interesting that I wanted to share with you. Arlene Kurtz applied for a job as a clerk typist with the city of North Miami. Now, that means her employer will be the government. When she was interviewed for the job, she was informed of a new city regulation that required all job applicants to sign an affidavit stating that they had not used tobacco products for at least 1 year preceding their application for employment. Kurtz, as a smoker, refused to sign the affidavit, because if she signed the affidavit, she's a liar. We will not accept that. And did not get the job for this reason, because that was our terms and conditions. She had to sign the affidavit. Just visualize yourself as you terms and condition drug testing, or I don't know, you have to say that's it. And the reason why that can be part of an application, the court says if you don't like that, you don't have to apply for the company. You can go to another company. Well, courts then sued the city of Miami, alleging that the employer request violated our constitutional right to privacy. I mean, what does the smoking have anything to do with her to become a clerk typist? And remember, the testing has to be related to the job, to the performing of the job. So smoking, I mean, does not interfere. Should judge consider in cutting health insurance costs when deciding cases involving employees' privacy rights? Is that something that the judge has to decide, or does the judge has to decide on what it is legal under the Constitution? The case was ultimately appealed to the Supreme Court of Florida, which held that the employer request did not violate Kurt's privacy rights. That means the lower court decided against or in favor of the city. That means the appellate court decided in favor of the city. And that means that the Supreme Court of Florida also decided in favor of the city. And them asking them to sign an affidavit if she smoked or she did not smoke for the past year, it was okay. It was not an invasion of privacy. Reasoning of the majority, because there was a dissent. And the dissent, really this dissenting judge is not the law. However, the dissenting judge may, in about 10 years, become the reasoning of the majority. In the court's eyes, the city had a compelling interest in reducing the cost of employee health care. This was the city of Miami. This was taxpayer paying for the health benefit of the people, of the employees. And therefore, that was a very good idea for the city to be careful to cut down on the cost, or at least the taxes. Evidence submitted by the city indicated that each smoking employee cost the city as much as $4,611 per year over what it incurs for non-smoking employees. So here's a situation that says, you know, we're not going to hire people that smoke because it costs the city of Miami more money. And if we pay more money for the people that smokes, then it's only fair that the people who do not smoke that gets the $4,611. There is no fundamental right to smoke, or even a legitimate expectation of privacy in regard to questions relating to smoking. There isn't such a thing. I mean, the right of privacy, you know, we're not intruding your privacy. We just don't want to hire people that do not smoke. And the Civil Rights Discrimination Act does not have anything about smokers. It has about color, race, ethnicity, national origin, gender, and religion, but not anything to do with lifestyle. So there is a situation. Again, reasoning of the majority in today's society. What does the reasonable people think about smoking? What do we know today about smoking? Smokers are constantly required to reveal whether they smoke when they enter restaurants, because they ask you, you know, when you sit in a smoking area. Hotels and car rental agency, for example. Therefore, asking question, you know, if you smoke before you go to work should be no news, nothing different. And of course, the dissenting judge says, wait a minute, here we have a slippery slope problem, because if governmental employers can inquire too extensively into off-job side behavior, a point eventually will be reached at which the right of privacy under the state constitution will clearly be breached. I mean, how far, where is that fine line that the state is asking question of site, you know, about your life that maybe you should not? Very interesting. Another one, he said, an example would be an inquiry into the lawful sexual behavior of job applicants in an effort to identify those with the most desirable style. You know, next thing you know, I might ask, if I want to hire people at my law firm, I might ask people, you know, do you play golf? Because if you don't play golf, maybe I will not hire you. And not so much, you know, sexual behavior, but I mean, do you like to go, what kind of music do you like to play? What kind of movies do you want to see? do you like country style furniture or not? And so, because I don't want to work with people that, you know, have different tastes than I do. The dissent also noted that the city health-based concern present a definite slippery slope of the court. If this is true, then that to save the taxpayer benefits, you know, paying for the benefits, and that means also private company to cut down the employment benefit. Are they going to ask the question like, do you skiing? And then, of course, if you ski, you know what happens. You might break your back, you might break your leg, and next thing you know, you cannot work for a couple of weeks. They might ask you any outside activity that might cost them more money because you might, do you ride a motorcycle? Do you ride a sport car? I mean, do you do anything that might cost more health benefit to the employer? The dissent also said the time is fast approaching, for example, when human beings can be generically tested so thoroughly that susceptibility to a particular disease can be identified years in advance. And this is what's happening today with technology. More and more we're finding out with technology that some people might have a gene for cancer. Some people might have a gene for certain diseases because it's hereditary or it's leaning toward that. And we can be tested by taking a blood, by taking a urine, and therefore the employer then does not have to hire you because, again, it's going to cost him more employment benefit. Are we discriminating then against individuals because of their bad habits? Very, very interesting. And again, who defines what is a bad habit? And that is the reasonable people, because remember, a corporation has to make profit in an ethical manner and also has to be socially responsible. And what is to be socially responsible? That means that the corporation has to fulfill the expectation of society at large, or how they believe or they expect a company to behave toward another individual, or the relationship between the company and the vendor, or between the company and the employee, or between the company and the consumer. And so if the society at large thinks that that's a bad habit, right now we have studies that shows that 55% of the people in the United States are not ready to accept the homosexual marriages, same-gender marriages. Those are the reasonable people, and therefore homosexual marriages, according to the 55%, it's a bad habit. In the next case, that is in your textbook, very, very interesting, there's medical privacy issue that comes up in the context of genetic testing. Here we go. This is the next step. And who knows, in 10 years or even 5 years from now, and it's a 1997 case, a research facility in California required all job applicants to undergo health examination to be eligible for clerical and administrative position. The applicants, 7 African Americans and 1 Latino, had filled out the questionnaires and give blood and urine samples, but did not realize that theirs would be among those selected to be tested for such conditions as syphilis, sickle cell trait, and pregnancy. Do citizens have a right to genetic privacy? Is the concept of a right to personal privacy determined by what technology can do? If technology can find out things about me that I don't have to tell you, does the employer or does the government has a right to have that information because of technology? Or is it something that, and again, remember, at the beginning of the lecture, the case where there is no privacy, when you tell somebody something, well, that means that there is no expectation of privacy if the doctor find out that I have a gene that is going to, give me cancer, for example. Here's an information then that now the doctor knows it and he tells me, that means I have no expectation of privacy to keep that information private, because according to that case, if I wanted to have privacy, then I wouldn't even go to the doctor to be tested for anything. Something for you to think about critically and ethically about this. Please read the case in the textbook on its entirety. I want you to see the due process situation. I want you to see the problem that we have, because more and more technology, and if technology can find out something about me, do I have then reasonable expectation of privacy? And of course, put your perspective on the discussion board. And this will be a good discussion about the right of privacy, which is constitutional law, and society at large. Thank you.